You wake up in a cold sweat in the middle of the night. Good God, did I get the evidence in establishing something that we all take for granted? And that's that bonus isn't an integral component of your compensation.
Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes or navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant and soon to be paralegal.
Very exciting. Can't wait for that. Welcome to episode 14 of the pod. If you've been enjoying Water Cooler Justice, take a moment to follow us, leave a rating, or send your favorite episode to a friend. We appreciate the support. Today, I'm excited to introduce two new panelists joining us, David A. Whitten and Cédric Lamarche. David is one of Canada's most respected voices in employment law, with over 20 years of experience helping both employees and employers resolve complex workplace disputes. As a founding partner of Whitten and Lublin, did I say that right? Is it Lublin?
Yes, you got it right. Yes.
As a founding partner of Whitten and Lublin, David is known for his strategic mindset, principled advocacy, and skill in constructive dismissal and termination for cause matters. His unique approach has assisted clients recover millions of dollars in severance. Whether he is negotiating high-stakes severance packages or litigating against unfair practices, David brings a results-driven, fair-minded approach to every case. Clients value David not only for his legal insight, but for his calm, composed presence in emotionally charged moments. His reputation for integrity, precision, and directness has made him an in-demand advisor in high-conflict employment scenarios. He has earned consistent recognition from Lexpert and Best Lawyers in Canada, and his firm, rated one of the top 3 in Canada, is known for putting power back in clients' hands. Cédric is a founding partner at Lamarche and has practiced employment law for more than 18 years. His practice spans the full spectrum of workplace law, including wrongful and constructive dismissal claims, human rights and harassment matters, employment standards compliance, contract interpretation, severance packages, and overtime disputes. He is recognized by his clients and colleagues for his pragmatic, level-headed, and approachable style, and is frequently retained by executives and employers involved in complex and high-stakes compensation, workplace, and restrictive covenant disputes. Starting in January of this year, Cédric launched CPL Resolutions, a practice focused on mediation, workplace investigations, and conflict resolution services. Fully bilingual in English and French, he is among a small number of employment lawyers in the GTA who regularly advise clients, conduct mediations, and lead workplace investigations in either official language. David and Cédric, thank you for joining us today. We're so glad to have you. It's a great panel. I'm really looking forward to the discussion.
Thank you for having us. It should be noted that David is my mentor from day one. I was one of his first associates at Whitten Lublin and learned quite a bit through those times there. I hold David in very high regard.
I love that. Too kind, Cédric. But at some point, the apprentice surpasses the master. And I think we're at that tipping point now where I like to say to a lot of employment lawyers, I've probably forgotten more employment law than most of you will ever know. I'm at that stage in my career.
So snatch the pebble from my hand moment for those who are old enough to remember Kung Fu, the show. Today's episode is all about bonuses, RSUs, and damages. Sarah, why don't you start taking our listeners through the case?
Great. Thank you, Chris. So today's case is Adelman versus IBM Canada. The plaintiff, Mr. Jason Adelman, began working with Platform Computing in August of 2004. Platform Computing was acquired by IBM Canada shortly thereafter. Over the course of his employment, Mr. Adelman took on various roles such as director, senior manager, and lastly, executive director, strategic partnerships. After 18 and a half years of service with IBM, his employment was terminated. He was 59 years old at the time of termination and was earning an annual salary of just over $240,000. He also participated in various company plans, including defined contribution match pension plan, annual incentive program bonus, employee stock purchase plan, and group insurance benefit plan. Mr. Adelman sued for wrongful dismissal, claiming 24 months pay in lieu of notice, entitlement to his AIP bonus, as well as entitlement to RSU and stock options that would have vested during the notice period, and aggravated moral and punitive damages. Now, at trial, IBM conceded on the length of the notice period, so the judge was ultimately tasked with qualifying Mr. Adelman's damages. So let's turn it over to our panel. We'll begin by taking a deep dive into the AIP bonus. IBM denied Mr. Adelman his 2022 bonus, citing his separation from the company as a contractual disqualifier. Despite IBM's position, do you think that Mr. Adelman is entitled to his 2022 bonus? And was he entitled to the AIP bonus during the reasonable notice period?
If I can start, I think
Yeah, please.
there's a key distinction here, right? There are two different bonus claims. There's the bonus that was earned or said to be earned in the last full year of employment in 2022. And then the lost bonuses that Mr. Alderman would have earned during the applicable reasonable notice period. And so with respect to that first claim, the bonus he claims was earned because he worked the full year. My understanding is the legal test that would apply for this determination was, number one, was the bonus actually earned? Sort of performance assessment based on the objectives that may have applied. And then if so, are there any contractual terms or conditions that limit or restrict that entitlement? And typically what we see, and I know David knows this well, is that you have to be actively employed on the date of payment in order to receive the bonus. And in most circumstances, that bonus is a bit of a trailer, right? So you work the full year and then it's paid out in, March or April of the following year. So the court did award this 22 bonus in the circumstances. And in doing so, it applied the first component of the test, right? Was the bonus earned, so to speak, in terms of performance objectives. And Justice Parji, who I understand was really, really excellent at trial in this matter, she focused on IBM's lack of good faith in making the determination that Mr. Alderman was not entitled to the bonus. And I'm sure you've seen she goes through the evidence that suggested that IBM had a pattern of basically putting a big no to employees who were on their way out or who had been severed. Actually, Mr. Alderman's own compensation statement indicated he was entitled to it because he was departing. And so there was a pattern seen by the judge here that they would skip over, departing employees when it comes to bonus. Now, David, did you see anything interesting about that determination about the 2022 bonus?
Well, I mean, it seemed to me like they did hang their hats on the sort of pernicious nature of the decision, with a lot of emphasis on the comp statement that he received, where it's expressly stated that he didn't get it because he was terminated. I think IBM would have had a lot more latitude to argue around the quantum or his entitlement if they'd hung their hat on something more performance related or otherwise. But I think you have something else in mind, and I'm not giving it to you. What did you see that I missed?
What stood out to me is the court didn't apply the second part of the test. Are there restrictions in place?
Yeah.
Conditional on the bonus payout? And in my view, had that assessment been done, it's possible that the court would have come to the conclusion that no bonus is earned. Because if we look at a different part of the judgment, so regarding the lost bonuses, the future bonuses,
Right.
the court explicitly references that IBM was taking the position that there was contractual language about, no entitlement after the cessation of employment. And that's at paragraph 35 of the judgment, if anyone's interested in looking at it. I'll read that portion. Or she indicated that she did not need to consider IBM's position on contractual restrictions because she determined that the 2023-2024 bonuses were not payable for other reasons. So it appears that there were some restrictive conditions at play here, or at least IBM advanced that position, but no assessment whatsoever on the 2022 bonus. So for me,
I noticed that as well. And for me, what I thought was very interesting about this entire judgment on both of the main issues, the quantification of the bonus and the RSU, a lot of emphasis on the documents, a lot of emphasis on evidence. And I think, that's a trend I feel like I'm seeing more in employment law decisions recently. Right? What do the documents say? And again, in this case, they're just like in our last episode, which I think was Brant Tractor. There's a suggestion that the people who were in a position to know didn't show up at trial, that the people who knew the answers or who had made the decisions didn't show up at trial. And for me, the thing that really jumped out from the 2022 bonus or the bonus earned section was that the court starts right off with Bain, right? And Bain v. UBS is an interesting case because even if employers have discretion, that discretion has to be exercised in good faith, right? And I think that a lot of employers can forget that, or in the moment, particularly if the termination was hard or if it was done for reasons that maybe didn't amount to cause, but there were some negative feelings or some performance concerns. That case, Bain, it comes up time and time again. Just because there's discretion doesn't mean you can just, you can just start at zero. And courts are going to look, right? Sure, go ahead, Cédric.
Let's speculate. Like, okay, we agree that there's a finding that there was a bad faith determination on the bonus entitlement. But setting that aside, if there were contractual restrictions that were valid, and Mr. Alderman was not actively employed when the bonus was to be paid, would he still be entitled to it in light of the bad faith nature and determining the amount or no amount of bonus?
Well, we don't have the analysis on the restriction itself, right? And so hard to say, I think. Active employment, I mean, that's a term that's come up lots of times on our podcast too, and we have some doubts about its efficacy in ousting common law entitlements, I think is fair to say. David?
I happen to run into... Oh, go ahead, David.
No, finish your thoughts, sir.
I was just going to say, I happened to run into lead counsel for Mr. Alderman at trial earlier this week at a function. So I briefly chatted with him, and I put this very issue to him. Obviously, he was successful on it, and he basically smiled and acknowledged that there were some incoherences in the judgment, but understandably didn't want to go further with that. I think he was happy with the result for his client.
Well, there you go. That is interesting.
I think, Sid, you've picked up on both of you, an interesting part of the judgment. Like, I think the starting point should have been the language of the plan. Because if there was limiting language, albeit hard to get it right, Chris, but if there was limiting language, because I think it is possible now to draft limiting language that, as long as it acknowledges the statutory notice period, could preclude somebody from claiming bonus compensation during their severance period. I think the analysis should have started there, because if there was limiting language that's enforceable, I don't think you do get to the discretionary element of whether it was exercised in good faith or not, because you haven't gotten over the first hurdle. But I think this is, first of all, I think the court got it wrong on the bonus for the severance period. I think that the judge focused largely on an evidentiary issue. And this is one of those things where I had this happen in a Nader UHN matter that I handled, where you end up you make all of your arguments, everything's done for the day, and you wake up in a cold sweat in the middle of the night. Good God, did I get the evidence in establishing something that we all take for granted? And that's that bonus isn't an integral component of your compensation. And this is something that I think we get somewhat complacent in the employment world around establishing this to the court's satisfaction. Because if I know when I'm looking at a summary from a client and you see they got bonuses 8 out of the 10 years that they were there, there's an assumption that made it an integral component of his or her or their compensation. And so how much time do I really need to spend on that in trial? And in Nader, we had a bit of a situation there because we didn't elicit direct evidence from Nader as to his bonus entitlement at trial and the fact that he had received it consistently throughout his employment. But thanks to the powers above, we had documentary evidence as comp statements for the last however many years that he'd been employed, that the Court of Appeal was able to hang their hat on to say, we have the evidence to establish that this was a consistent component of his compensation. And so, oh, Mr. Whitten, you lose on the main point of your appeal, unfortunately, but you win on the bonus issue. So it's just one of those things where I think if you look at paragraph 30, where they kind of identify there's no evidence to suggest that the bonuses were required by IBM. And this is another element of it too, like this concept that part of it is whether bonus compensation is necessary to remain competitive in the industry that the person is in. Like, that's the first time I've seen that element. And Sid, I wanted your opinion and yours too, Chris, on this, because like that jumped out at me too. Like, since when did that become part of the analysis? It's either it was an essential component of the compensation, there's limiting language, or it's not. Why
Well,
is
I have a suggestion for all my management friends and clients, and that is if you're talking about market competitiveness in your bonus plan at all, it's time to remove that language.
yeah,
I have never actually seen that either, where
okay.
market competitive. I have seen it with the idea that RSUs, which we'll talk about shortly, are about retention and market competitiveness for retention purposes. I've seen that discussion before. I've never seen it directly to the severance bonus. And the other thing I'll say about bonus during the notice period, I mean, the presumption is you get it.
Yes.
And so the thing, I thought there were two interesting things here. One, they talk a lot about this skip rate. So this particular employer had a practice where they had a minimum percentage of people who didn't get a bonus. So whether it was 10% or 20%, that bottom group, that bottom tier did not get a bonus every year. And so I thought that was actually quite interesting because, I mean, if I was at trial, I would have leaned heavily on that. And I think that might be part of the reason IBM had some success. It's unusual. I don't know that I would want to work someplace that had that policy, but I do think it's effective in this context when you're arguing about whether there's an entitlement. The other thing is I've never seen percentage of gross salary, the bonus calculated as a percentage of gross salary to determine whether the bonus is integral. I've seen the discussion, as a percentage of the total comp. I've seen that, but I've never actually seen a court, get down, like we're down to decimal points here, 3.6% in 1 year, 16.6% in 1 year. I've never seen a court get right down into it. So again, I think this judge really, really, really was focused on the evidence, and the judge was listening very, very closely to the evidence. And to your point earlier, David, it's something that sometimes there's an assumption, that the courts are familiar with Bardolph factors, or the courts are familiar with the basic underlying tests for standard forms of compensation. And it's not true. This case is a good reminder that you got to show up with your documents and you've got to show up with your evidence organized. And it's a good lesson for employers, and it's also a good lesson for employees, right? In terms of, what you should be hanging on to, when you're getting annual compensation letters that have your bonus and your benefits and your RSUs all sort of set out for the year, and your annual raise, whether it's 2% or 0%, or you got a skip rate bonus of 0%. If you're hanging on to those letters over time, you're going to have a far better evidentiary record if there is ever a dispute about an entitlement post-termination than if you don't. And so employers that are providing that information, hats off to them. I think it's great because it helps the employees understand that their contributions are valued. But also to employees, I would say, hey, these are good. These are good documents. Get a little file folder, tuck them away, or in this electronic age, right? Create a file folder in your personal Gmail account and tuck those documents into that file folder. Because you never know, as we learn in this case, you never know what's going to be important or what the judge is going to focus on. And the last thing I'll say about bonus earned and severance bonus is there's a lot of lawyering for $25,000,
Yeah.
right? Like there's a
Absolutely.
lot of litigation here
Yeah.
and if it was $25,000 a year, what are we talking about here? $75,000 total. This is a $682,000 judgment. Spoiler for those who didn't know, but like we spent a lot of time fighting about that last 75%. I think it's Howard Levitt that always talks about how the last 10% of resolution is the hardest. But sometimes you have to ask yourself, was it worth it? And maybe we'll look at the cost award a little bit later on too.
Yeah. 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 I was speaking to Bizad Hassabi, who's lead counsel on this with Chris Foulon from Israel Foulon, both great lawyers. And I asked him about that, the level of assessment on the integrality portion of the judgment was kind of unseen in my opinion. And I talked about, appeal. And I think astutely he said, look, we got really good results on the other counts. We didn't want to put that into jeopardy, possibly through a
Yeah.
cross appeal, and the quantum on the bonuses just wasn't worth it. And if we look at the cost endorsement as well, like you mentioned, it was very, very healthy here.
Yeah, it's, well, we'll get to it in a bit. Sarah, maybe you want to wrap things up for our office here, or wrap things up for our audience, I should say. Why do
Of
I want to take
course.
ownership of this decision? 682,000, which was mine.
It's a big win.
So, to sum things up for our audience, the court found that Mr. Adelman was entitled to be paid his bonus for 2022, including the associated 4% pension contribution. The bonus claimed for the notice period, however, was speculative. It was found not to be an integral part of his compensation, and the court declined to award it.
All right, let's turn our attention to stock options and RSUs. Just a brief refresher, restricted stock units, or RSUs, are a form of equity compensation, often used by employers as a retention tool. They vest over time and can form a significant portion of an employee's overall compensation package. If you haven't already, I'd encourage you to give episode 10 of our podcast a listen. With our guests Ellen Lowe and Sean Bodden, we explore some of the bigger picture questions surrounding RSUs, including whether they should be treated as wages or benefits for the purposes of the ESA, how good faith and employer discretion factor into forfeiture decisions, and what the future may hold for equity-based compensation in employment relations. So I, just so you guys know, we have a lot of concerns about how weighted RSUs are becoming in the compensation schemes, and the fact that RSUs are not really addressed as regular wages in the ESA, or at least it's unclear whether they're part of regular wages or regular benefits for the purposes of the ESA. And so we spent a lot of time talking about that in some previous episodes. Sarah, what do we need to know about RSUs in this case?
Right. So this is where it gets really interesting. So Mr. Adelman asserts that the damages should reflect his usual selling practices. In other words, the value that he likely would have realized had he not been terminated. IBM, on the other hand, argued that the damages should reflect the value of the options as at their respective vesting dates. So we're left with two competing methodologies. David, Cédric, and Chris, what are your thoughts on these differing approaches? And my second question is, RSU entitlement is a fairly topical issue at the moment. With respect to both of your practices, have you encountered a higher frequency of these types of disputes, and what's your experience been like?
Let's start with David for this one.
Yeah, I think the methodology used for calculating the damages is interesting, and bearing in mind the
The
well, in as
diplomatic.
much as it's interesting. I say that because I think it's problematic ultimately to use as a sort of rule of thumb going forward, because not everybody exercises or sells their stocks in certain regularity. I mean, it's often very hit and miss, very ad hoc. And so I think maybe in this case, it was possible to identify his selling practices fairly easily, but most of us, most other investors are far more sporadic. And so if the court's going to go down that path, it's going to be really hard to sort of like, what are you going to plot data points on a graph and then try to find like a consistency when, throughout. And I think that could be hard to do. So I think the IBM approach suggestion was an easier, more straightforward approach that could be applied more consistently than what they've done. But I say interesting because I think, in keeping with that first principle, that severance is supposed to put the person in a position that they would have been in had their employment continued, it makes sense conceptually. I just don't think that from a practical perspective, it's tenable in every case.
Well, so I didn't go back and read. Unfortunately for IBM, at trial, sometime between the commencement of the action and before the trial, a decision came out in another matter called Millwood. And in that case, the RSUs were granted, and IBM was the defendant, and it was this specific plan that was considered in Millwood, right? So IBM, unfortunately, they had a significant hurdle to overcome. I don't know how late springing it was, when they became aware of the other decision. Um, But for me, what I didn't see was an analysis of the practice of the employee in Millwood,
Yeah. Yeah.
right? And so, like, I was sort of sitting, I was like, why didn't they just do whatever the valuation scheme was in Millwood? Why are we having this discussion? But the court engaged with it. Cedric, any thoughts?
Yeah. So after Mr. Alderman's termination, which was in January of 23, IBM didn't cancel all of his unvested equity. They actually allowed
Yes.
one
Yeah.
tranche of equity to vest in February of that year, and then it canceled everything else that was supposed to vest in February of 2024. And Mr. Alderman waited about 400 days or so before he sold or exercised the vested equity in February of 23. So the court looked at that. It looked at his post-termination conduct in determining his, investment philosophy or conduct. And it didn't consider anything else. Like, it didn't consider termination investment practices by Mr. Alderman. And to David's point, I definitely see the rationale in the court's approach, in the sense that, what would the person have done but for, the failure to give proper notice of termination? And I think that is correct, generally speaking, based on the case law and the concept of wrongful dismissal damages award. But I was really intrigued by the focus on only post-termination investment conduct. And in doing so, the court here in Alderman relied on the decision of O'Reilly versus IMAX, which was appealed and upheld on appeal. And in O'Reilly, it was determined that the plaintiff's post-termination investment, conduct was determinative of the best evidence of what he would likely have done with his equity after termination. But so on its face, it seems sound to rely on that authority from the Court of Appeal. But if we look closer at the trial decision in O'Reilly, and there are supplementary reasons specifically on the valuation of the equity, the court noted that it preferred the plaintiff's post-termination conduct because during their employment, they were subject to insider trading policies. So the employee had to sit on his vested equity for months. I think it was like 13 months or something like that before they could sell or exercise them. So I said, well, that's not an indicator of what they would normally do. So all we have is what the person did post-termination. And so I think that was an important nuance that was kind of missed and that wasn't considered. And now we have this judgment that says it's only post-termination investment conduct that really matters that we're going to focus on.
Well, but as you say, O'Reilly's Court of Appeal, this is a Superior Court decision. I think you can probably persuade a judge in the future to look more closely at O'Reilly and the reasons in there. But I picked up on that point too. I thought it was great. I had, beside the paragraph where the one tranche was awarded post-termination, I wrote no good deed. And then, my other thoughts were, as I was looking at this valuation paragraph 63, so where they're talking about O'Reilly, the thing that I really struggled with, and I'll put it back to you guys, is, okay, so I get my RSUs, and there's a 20% spike in the share price, and an open period hits, and the president of the company sells 75% of his shares, right? Well, I'm pretty sure I'm selling my stuff too. Right, price is up, and the insiders are taking earnings. Right,
Mm-hmm.
I think I'm taking earnings too. Right, and so one of the things I didn't really understand was why would what you happen to do with one particular set of units, or why would your investing policy for a particular period of time inform your investing your sale decision at some point in the future? There's so many factors, right?
Well,
And so, what do you guys think about that, David?
Well,
Maybe.
100%. Like Chris, like the investing strategy is usually, if done properly, ad hoc, not on a timer, right? Like we don't all review our portfolios every 6 months and sell everything in them. You watch the various market factors, take advice from other people, etc. So I think it's really problematic. And I think the bigger problem is this now provides an opportunity for employees to cherry pick. It's now
Right.
competing decisions. Like if the stock price was higher on the date that it vested, well, that's how I'm going to argue my damages should be calculated. Or, hey, stock wasn't great there. 6 months later, it was higher. So maybe I'm going to cobble some argument now that I typically divest myself of stock every 6 months. I mean, if we're looking for certainty in the litigation process, this has not provided any certainty at all.
I agree. It does not help with certainty. And a little bit of chaos helps settle files, particularly earlier, right? There's anecdotes about how quickly employment files settle and when they settle and why. Often you hear some kind of percentage about the number of files that settle at mediation or sooner. I think that the unpredictability might help a little bit in terms of resolution, but I think it's unfair to employers. How are you supposed to advise your employer client what to pay on the equity if there is a common law
How do you
entitlement?
accrue for it?
Because now we don't know. Now we don't know how to value it, right? Or it's the same with notice periods. So we've been talking about this a lot on our podcast. Short service employees, where the notice periods are, the range is actually quite wide lately. And so, how do you advise an employer who's terminating a short service employee in this particular economy? I mean, you really have to either get down into industry specifics or Bardolph factor, find cases which are really Bardolph factor specific and on point with your particular employee and in your particular industry to have any real chance of persuading plaintiff's counsel that this is a fair and reasonable offer at the outset. Right. I mean, certainty is what courts are supposed to provide. And I think you're right, David. I think that selecting this particular valuation approach doesn't add certainty. But what if I exercise my equity the day after it's vested every time?
Well, you want to talk about uncertainty? Let's talk about the elephant in the room, Wigdoor and Facebook.
We just had an episode on that 2 or 3 episodes ago. I love that case. Wow.
How can RSUs not be considered wages? Sorry, you said it's not clear in ESA. My view of it is and it's determined in congruence with the Income Tax Act. RSUs,
preach, David.
They're considered. Well, when I'm on the plaintiff's side, this is all right. So I'm on the plaintiff's side today.
No, but I agree. And it seems to me grossly unfair
it's income from
that
employment.
So much of your compensation can be tied up in a form of compensation which isn't addressed by the statutory minimum protections. And I've had a management counsel come back to me and say, "Oh no, the equity is governed by the state of Delaware. You can't bring that claim here." Or, "Oh no, right? This is separate from the employment. It has nothing to do with the employment, except the only reason he's getting options is because or RSUs is because he works for you." It for me, there's a bit of a disconnect, and I understand why it existed at the start. I understand, I'm old enough to remember when maybe RSUs weren't as common a form of compensation, right? I understand why at the start there was a temptation to treat it differently.
Yeah.
I don't know that I'm there today when so many employees this is a substantial portion of their compensation. And for example, there are even companies where there's a slider, and you can slide the slider to the left and take less salary and more RSUs, or you can slide the slider to the right and take more RSUs and less salary. And those employees, oftentimes, they have no idea that what they're setting themselves up for is a nasty exit. Now, if they last and it vests and they have the opportunity to exercise, then they've made perhaps a better financial decision if the value of the shares goes up. But I agree. Like there's a real problem. There's an uncertainty. Cédric, you have thoughts on ESA and RSUs?
Yeah, well, going back to this concept of the valuation methodology used in the case that was applied, and to David's point, like I think it's problematic from an uncertainty perspective or certainty perspective. When we look also at like post-termination practices with these equity awards, I mean, a lot of these plaintiffs just lost their jobs. They're being denied a substantial portion of their severances.
Good point.
They're fighting for it. They're litigating. They're spending money on legal fees. Their court date is, going to be 3 years out.
3 years?
So what are they going to do?
Those court dates, Cédric? I thought we were looking at 5 years in trial these days.
Well, if you're in small claims court, no one knows, right?
I want to know where you're filing, brother, so I can get in there too and get a 3-year court date.
I know people, David. Um,
Helps to know the registrar. Sure, got it. Yeah.
so it's understandable that a lot of these plaintiffs are going to liquidate their equity right away to
Exactly.
get some funds in and pay the mortgage and keep the lights on at home, right? So I think that's highly problematic, and the lack of certainty there is a big problem in advising, especially on the management side, right?
Well,
Before
yeah,
we
like I
run
don't
out
know
of,
how to value them now.
well, I don't either. I just know I'm going to pick the best one for my client now. Hey, can we cobble some argument that you sell every 3 months? Sure, let's go with that if the stock price was higher than it was on the date of vesting.
Yeah.
But while I
Yeah.
got these great legal minds on this call in this podcast, I have to get your opinion on saving provisions and otherwise unenforceable language in long-term incentive plans. The Waxdale analysis, right? That
Okay.
you can't otherwise save language. So Waxdale stands for the general proposition. Anybody listening to this call is probably overly familiar with this.
Well,
It's
we've
just
talked
that,
about it.
yeah, well, of course, because Chris has pulled it apart with Sarah's capable assistance, probably to the thread. But the concept being that you can't state in one part of a termination provision something that's offside employment standards legislation and then save it with a throw in subject to employment standards legislation, or if the Employment Standards Act says otherwise, you get what the Employment Standards Act calls for. So we know in severance provisions, the law seems to be pretty clear in this regard. You can't save it if the first part of the provision is unenforceable. But if we look at the IBM provision here, and you had to go back to Millwood to look at the language, which I pulled out, they do have saving language in their definition of termination of employment, because it says your termination date for the purposes is the later of the following dates, the date you cease to provide services, blah, 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 or the date upon which the employer is required by statute to pay termination pay in lieu of notice of your employment. So it's either earlier of your active employment or it's the date that your ESA minimum period ends. And so they had that language in here, and it would appear that the court rejected it because it doesn't save this otherwise provision. But they don't talk about that. They don't get to the saving provision in Millwood or this decision. They just talk about this regardless of whether such date creates an ambiguity in the first part of it. So guys need to know, guys and
Yeah.
gals and non-binary, what is it? Can you save an otherwise unenforceable termination date definition with a throw-in subject to employment standards legislation?
Cedric, what do you say?
What is a savings provision, right? It boils down to that. Like, is it a separate paragraph that say, notwithstanding the
Right.
above, you will always, get your full entitlements under the ESA? Or is it a baked in continuation of a sentence or paragraph that says this, or in no event, will you receive less than that?
Well, but
right?
I agree. Like, what's the difference? Just because it's two separate paragraphs, offending paragraph and savings paragraph, we know that the savings paragraph won't save the offending paragraph. But simply by incorporating both concepts into the same provision, I don't understand. I've struggled with that myself. I don't understand why that isn't ambiguous at least. At least, right? Because what is it?
Yeah.
Right. And it's basically just a form of greater of provision, which we know is not enforceable, right? Or we know that
Yep.
if a greater of provision offends in some way, that it offends for all purposes, right? And so I've always struggled with why the courts seem to be prepared to enforce that provision. Right. And I think somebody should take a run at it on that sort of same principle as the greater of. It's really asking the court to pick which one applies.
Mm-hmm.
And maybe the language is maybe by taking it out of that greater of, and then you've got A and B. Maybe something about the syntax or the grammar of the structure, but conceptually it seems very, very close. And the court doesn't have any problem saying greater of is not going to fly.
Well, I think it's all about the syntax and grammar according to the cases we have. Like if you look at
Yeah.
Liggett and Viva Software Systems, they said it was they had also saving language. It said, in the event of termination of your service for any reason whatsoever, or the terms of your service agreement, if any, except as otherwise expressly required by applicable employment standards legislation, it's the end of your active service. And the court said, not safe, doesn't work. But what if it had said, except move it, except as otherwise required by employment standards legislation, your last day of active service is the date that we tell you. Would that have changed it?
Well, again, I really struggle with those. I've struggled with how to advise clients on those for sure. The other thing I'll say though, and maybe the magician doesn't like to tell all of the secrets behind the tricks, but it seems to me that a lot of forms of incentive compensation are regular wages, and the ESA formula for people who do not have a regular work week, which is a lot of my clientele, um, requires that you take the money from the preceding 12 weeks and average it in. And so any kind of provision that says you don't get, I think, offends the formula which underlies the calculation of a regular wage for a regular week. So we're like way inside baseball here now for the listeners. But so I'm looking at a definition of a definition basically within the act here. But I think that formula is probably the answer to a lot of those questions, because I think those provisions offend the formula,
That's a great
right?
point. Yeah.
Yeah,
And
very good
remember,
point.
the regular wage formula doesn't just go beyond notice where you're not allowed to make changes. It goes for statutory severance too,
Mhm.
right?
Yep.
And so, I think the provisions probably, like that's your provision. If that's the provision you're giving your management clients, you might want to think about it, because somebody will make that. Like, I haven't had a chance to make that argument, but somebody will. And in the same way that, the greater of argument, I think, seems to, the same analysis for greater of seems to apply to these provisions where it's all baked in. I don't think the word accept is a whole lot different than or,
Yeah.
right?
Or just to make sure we're all aligned here, as long as you're employed and paid in Canadian soil, Delaware law doesn't matter to interpreting these provisions, right? Am I right about that? That's where I'm coming from. Like, I don't
I,
care what the laws of Delaware are. You're in
I'd
our
say
country.
that. I'd say that, David, but I don't want to be the guy that ends up blowing it for everybody either, right? As management's going to make those arguments. And as long as you have, I mean, it's Ontario courts specifically, right, on RSUs and equity compensation.
Yes.
We have a string of Court of Appeal decisions that aren't really consistent with the Supreme Court of Canada's guidance in Matthews. And so that's the tension between the Wigdor case, I think, that David mentioned, and the
Mhm.
Liggett case that I think Cédric mentioned, right? In one case, Liggett, they get their equity compensation. In the other case, Wigdor, they don't, right? I think that we do have a problem in Ontario, and we do need clear resolution, and hopefully we get some guidance from the Ontario Court of Appeal in Wigdor. But the thing I really like about Wigdor is he sold that company, and he got a lot of money to sell that company, and the judgment even talks about how much money he got to sell that company in denying him the compensation that he negotiated as part of the sale. And so I think if there's somebody who has the ability to take this line of Ontario Court of Appeal decisions all the way to the Supreme Court of Canada, and if there was a case that sort of screamed out for some guidance from the Supreme Court of Canada, particularly for Ontario courts, it might be Wigdor, right? I
Yeah.
think the facts are good. I think the plaintiff
Mhm.
is able to go the distance. I think the value of the units warrants it. And so I'm hoping we can get some guidance. But I agree, the thing I also am fascinated about with Wigdor is it ESA compensation? Is it somehow captured by the ESA? And if it is, why isn't that determinative? Or at least why doesn't that give us a starting point for, which portion of the compensation must be paid at the outset of termination? To Cédric's point, like, I don't care how much money you make, your lifestyle typically will reflect your income. And the
Mhm.
sudden loss of income, on a few weeks' wages, which is what the ESA provides, right? Especially if you don't have 5 years or more of service, is devastating for everybody. I don't care if you make $1 million or if you make $10,000, right? No one can really afford in Canada to lose their stable employment, to lose their income on 4 weeks or less notice, which is what the ESA provides for employees with less than 5 years of service. So, like, I do think we need some guidance there.
Yeah.
Yeah,
Yeah,
but
we're
look,
like
the Supremes didn't weigh in on Waxdale. I don't know if they're going to weigh in on this one, because I think they look at it as more of a regional kind of Ontario problem because of the way our legislation is defined. Like,
it's fair.
I mean, I thought they
Yeah.
were going to come in on Waxdale, clarify for all of us, but I think they got to it and they're like, this is an Ontario problem. This doesn't go across all the provinces. So I think you
I
might.
well, but I think there is a real tension between Liggett, which looks at Matthews, which is a Supreme
Yeah.
Court of Canada decision, and Wigdor. And so
Yeah,
maybe
big
we
time.
do need a little bit of help, or maybe we just need to know how to reconcile those two competing lines of reasoning.
100%.
Yeah.
Well, because Liggett does say as much in paragraph 48, like this violates the ESA. So then,
Right.
And we're like stuck in this I'll call it an artificial like distinction between stock options, which are employment related, and RSUs, which are a commercial arrangement. And then the contractual analysis will differ significantly because when a court looks at an employment agreement, an employment related contract, the assessment, the interpretation is very, very different than in a commercial agreement and commercial arrangement. Why are we having this distinction when it's all related to the person's employment and employment relationship with the company, right?
well, pump the brakes. Lamarche,
Yeah,
let's
yeah.
go
Whoa,
too
whoa,
far.
whoa, whoa, whoa. I agree.
Whoa. Stock options, actual stock, they're taxed differently. They're considered a capital gain. Like, I think there is a clear distinction between the two. Like RSUs are taxed. It's income from employment. There's no avoiding it. And if you want to look at the commercial nature of it, as a stock option holder or a stockholder, you're often, if it's a privately held company, you're going to be part of a shareholders agreement or otherwise. So it is a much more commercial type relationship. Now, I didn't say this when I'm on the plaintiff side. Again, I'm arguing a stock option investing, but I do see in conceptually there being a big difference.
Yeah, the other thing maybe I'll mention about RSUs is there's a distinction between the kind of units that pay you in shares and the kind of units that pay you in cash, right? There are some RSU programs that are actually not equity based. They track the equity, but the payments flow. Sometimes they're called phantom share units,
Yeah.
and the payments they're just cash, right? And so I've always struggled with, well, that just looks like a wage to me. Like it even goes into the employee's payroll bank account, right? Like. Often it's cashed at a time of the employer's choosing, right? And so, like for me, I really struggle with that particular type of compensation somehow being deemed to be outside of the ESA.
Well, here's a teaser for one of your future podcasts. Do RSUs, do they attract vacation pay then? Would you be getting 4 to 6% of your RSUs as well? Class action, anyone? Class action?
4 to 10%, baby.
Yeah.
I love it. That's great.
Lamarche, what do you say? I know you said, you're pretty even-handed on both sides of the table. What do you think?
I mean, for me, it boils down to why are these, items of compensation being offered or awarded? It stems directly to the employment relationship. So this
Keep it
is my
simple.
struggle, right?
I
Whatever
like
you
that.
call it, you're an employee, and that's why you're getting these awards.
It's
Right.
fruit of the
Directly
employment,
related to the relationship,
fruit of the employment tree, right? Yeah.
right? Whether
One
it's
of-
a retention tool or a reward, it's because they're employees, right? It's different if I buy shares in a company, I'm a shareholder and I have no other relationship. I'm a silent, owner or investor. That I get, right? But when those awards are coming directly because of your employment relationship, and often these are signing bonuses, right? We'll give you an RSU award of X amount if you join us right out of the gates. Like, how is that not viewed as directly related to the employment
Well,
relationship?
yeah, or those
So that's my
comps,
struggle.
the comp statements you get at the banks and a lot of financial institutions that include in the big pie chart the value of your RSUs or stock options or whatever. Like that's described as your compensation.
Right. Those are those letters I was talking about, right?
Yeah.
Hang on to those, right? They're
Right.
great evidence.
Yeah.
So I had a lot of fun actually today, guys. I want to thank you, David, for actually bringing up those provisions where the saving provision is now buried into the actual language.
Yeah.
You don't get except if the ESA says you get. I don't know that should be enforceable, but I don't know that it shouldn't. And so I've been struggling with that one a little bit. If you guys become aware of a case that deals with it, or you want to come back on and talk about that issue, I'm sure we could do a whole episode on it. I'm super interested in that.
I'm going to throw down. I think it all comes in the order of how it's worded. If it starts with except as required by employment standards legislation, termination date is X, it can't be said that you're trying to save an earlier provision is otherwise unenforceable because you've opened with except as required by employment standards legislation. Versus if you say termination date is the last day you're providing services, if we look at like the language in this case, except as required by Employment Standards Act, you get X. Like that's later, that's a saving provision that's trying to save something that was stated before. So that's my opinion on it. It really depends on where it falls within the provision.
I
mean,
like the approach.
I think the problem for me is that those provisions lend themselves to abuse, right? Like most employees don't know the Employment Standards
Well,
Act like we do,
that's
right?
a
And
great point.
they're gonna read that and they're gonna think that in certain circumstances that are identified in their contract, they're not entitled. And ignorance is, no defense in the eyes of the law. And if the employees are, don't go to an employment lawyer or don't know to go to an employment lawyer, I guess that's okay. But as a matter of public policy, I don't particularly care for those provisions.
Yeah,
Right.
no,
I think I would much rather that the employer just say something like, we will terminate you in accordance with the Employment Standards Act and you will receive all of your entitlements thereunder. And if they really want to make it clear and you acknowledge that in some circumstances you may receive only wages earned and vacation accrued up to the date of termination. Right. Like it doesn't have to be as not deceptive, but as indirect. Right. I would prefer direct plain language. I think, and Birch v. Data Stealth, right? So we have at least one
Yeah.
provision that's been enforced. I don't know why everyone wouldn't just. I don't know why everyone just wouldn't park that into their agreements. But
I think we overthink it.
right, right.
yeah,
Like I do think that's part of the problem. I also think that what happens is employers over time make changes to the precedents that they receive. And, there's a temptation to say, yeah, you can have this and you can have that, but you can't have this, right? On termination, you can't have your car, or on termination, you can't have, we're not going to extend benefits, or whatever it is. And I think that's where they get themselves into a lot of trouble too, employers, is that, they're working with something that was enforceable, and it's become unenforceable either because they've made changes over time or because the law has changed. And oh my goodness, is the law ever changing right now? Right?
yeah.
Like if you're management and you're working in Ontario, if you've got employees in Ontario and you want to make sure that your ESA provisions are still enforceable, good time to get in to see your management council, your employment council, because I think there are several matters that are under appeal. Wigdor being one of them. Um, I'm trying to remember the other one. The Lee and Wayfair, I think, is the
Wayfair,
other one.
yeah.
At any time, right? So there's at least two significant decisions that are being considered by the Court of Appeal, and I'm sure you guys are waiting with bated breath to get the Court of Appeal's reasons on those. I know I have a bunch of files that have been backed off, to mediations a little bit later this summer or in the fall, because we'll know hopefully one way or the other by then. But
Yeah,
until then,
I'm just going to weigh in on this point too, because
yeah.
I think we're doing our country a disservice with all this navel gazing around the enforceability of these variety of severance provisions, because nobody's going to want to do business in Canada if you can't quantify severance obligations going forward. I mean, there's a whole bunch of reasons people don't want to do business in our fine country, but now you make it even harder for businesses to quantify severance/reorganization costs. Yet another reason why you're not going to want to come here and open up a satellite office or a primary business. So at some point, we all got to get our heads out of certain orifices and start thinking like, is this really what's best for our country from a public policy perspective to give employers no certainty at all as to what they're going to end up having to pay upon termination?
Well, so I just flashed back to my days in the infantry there, but what I will tell you is,
Sid's been there too.
yeah. So I was in the infantry for a few years before I was a lawyer. But what I will say is, I think Birch v. Data Stealth probably answers a lot of those questions. Right? That's an ESA minimum provision that's been enforced by an Ontario court.
Yeah.
Cut and paste,
Keep it
and
simple.
you're
Yeah.
probably in reasonably good shape. It's as you say, it's the provisions that want to go a little bit further, right? It's, except as, or, we can terminate without any payment except if we are required to by the ESA, or if this RSU compensation, is it a wage? Is it a benefit? Is it covered by the ESA? Isn't it? Right? Those kinds of uncertainties we should try to resolve. I absolutely agree. But
which works with a minimum clause, right? Like all you get is ESA, but an employer says, no, I don't want to, give minimums. I
Because
want a
nobody will agree
formula.
to that. Yeah.
I want a formula months per year or whatever. Then we get into this issue again, right? How do we craft this clause properly?
well, so again, Barry Fisher, a friend of the pod, and full disclosure, when I first opened my own practice, I started at 393 University on the 20th floor. So that was where Barry Fisher, a prominent mediator, had his office, and there were several other employment practitioners up there. And I was a young guy, and so they all sort of took me under their wing and brought me along. But as Barry often says, just give the ESA plus a little bit more, right? And you're probably on the safe side. And I kind of agree, right? But to your point, Cédric, I think what you're saying is, if RSUs are actually covered by the ESA, right? How do we calculate that now when we don't even know what the valuation process is? Is it, especially if it's dependent on the past practice or the post-termination practice of an employee, right? So I'm gonna bring us to a close there because we're up around an hour. I could go all day with you guys. This is great. I really had a good time. I love, as you get it, I love talking about employment law. I can see you guys do too. I can't wait to bump into you at another conference and we can pick up where we left off. Or hopefully you'll come back and join us again as panelists on the podcast. That concludes today's discussion. I want to thank our panel for the great conversation, Sarah for keeping us on track, and our listeners for tuning in. If you like this episode, please subscribe or leave a review. If you have a case you'd like us to discuss, or if you'd like to share your own story of workplace drama, and we love workplace drama, email us at watercoolerjustice@gmail.com. Until the next time,